And we begin here in Washington, D.C., at the D.C. District Courthouse, where a judge heard oral arguments today in a case to put an end to some of the NSA's spying activities. The two issues at hand were the NSA's bulk telephone metadata collection program, which we know targets millions of Americans, as well as the NSA's collection of Americans' internet data under its PRISM program. Both programs were revealed by Edward Snowden. U.S. District Court Judge Richard Leon summoned Department of Justice lawyers to defend those programs against Larry Klayman, a lawyer for the conservative group Freedom Watch. He's filed 2 lawsuits against the NSA and is asking for a broad preliminary injunction to put an end to those programs immediately. And this appears to be a case that Judge Leon is very much interested in hearing. Back in October, as government lawyers pushed for delays, Judge Leon lashed out, saying, "I don't want to hear anything about vacations, weddings, days off. Forget about it. This is a case at the pinnacle of public national interest. Pinnacle. All hands, 24/7, no excuses. The Department of Justice, the NSA, the allied government agencies that have an interest in this have had 4 months to think through its position. That's a lot of time." An interesting note about Judge Leon: in 2008, he ordered the release of 5 Algerians detained at Guantanamo Bay, citing the government had no evidence proving they were terrorists. Now, one of the main issues in this case, beyond the constitutionality of these spy programs, is whether or not the D.C. District Court has the authority to overrule the opinions of the top-secret FISA court, which has already signed off on these surveillance programs. The ACLU is also challenging the FISA court's decisions on these programs, particularly the phone metadata collection program. On Thursday of this week, a district judge in New York will hear arguments from the ACLU directly targeting the NSA surveillance of millions of Verizon phone users, again, as revealed by the Edward Snowden leaks. But while the NSA lawyers up in district courts this week, it's received a free pass from the highest court in the land. Today, the Supreme Court denied a case brought by the Electronic Privacy Information Center, EPIC, that also challenged the NSA's collection of Verizon phone records. It would have been the first major NSA challenge to be heard by the Supreme Court. Now, court cases aside, there's another form of backlash the NSA is dealing with since its secrets were dragged into the sunlight. The agency says it's seen an enormous surge in open records requests coming from Americans who want to know exactly what the NSA has on them. Staff at the NSA Freedom of Information Act and Privacy Act office are overwhelmed by an 888% increase in open records requests since the Edward Snowden revelations. Though Americans who have contacted the agency for information have all received the same form letter informing them that the NSA cannot confirm or deny whether or not they're a subject of surveillance. And moving on, the NSA isn't the only agency fighting against transparency in the courts. So too is the Department of Homeland Security. Last week, a federal court here in D.C. ordered the Department of Homeland Security to disclose details about the Internet kill switch. Now, what we're talking about here is what's known as Standard Operating Procedure 303, which is the Department of Homeland Security's ability to shut down entire communication networks, basically preventing people in the area from using their phones or their internet. DHS says the procedure is necessary in times of crisis to prevent detonation of a remote-controlled explosive. The procedure was approved in 2006, but no one really knows under what pretext DHS is actually allowed to flick the internet kill switch, and some fear it could be abused. During a protest against police brutality in San Francisco in 2011, Bay Area rapid transit officials disrupted activists' plans by turning off the internet and cell service for 3 hours at 4 different transit stations. Now, following this, the Electronic Privacy Information Center filed a Freedom of Information Act request for the Department of Homeland Security to hand over its plans to activate the internet kill switch to determine whether or not the procedure violates free speech rights and public safety. DHS previously argued handing over such information could hinder law enforcement techniques and prosecutions, but that argument was tossed out by last week's federal court ruling. But the court did leave the government some wiggle room for an appeal, noting the court is not unaware of the potential adverse use to which this information could be put. Its ruling, furthermore, is no judgment on whether it is in the national interest for SOP 303 to be disclosed. If, in fact, the government believes release will cause significant harm, it has other options to pursue. The Department of Homeland Security has 30 days to hand over information or file an appeal. Now to one organization that doesn't rely on the courts to have information released, WikiLeaks. Following last week's sentencing of Jeremy Hammond to 10 years in prison for his role in hacking the servers of the private intelligence firm Stratfor, WikiLeaks on Friday released 500,000 new Stratfor documents. WikiLeaks announced the dump on Twitter under the hashtag #FreeHammond, bringing the total of Stratfor files released to over 5.5 million. The original Stratfor document dump back in the beginning of 2012 contained some bombshell allegations, including claims that the U.S. government had a sealed indictment against Julian Assange and that Pakistani military and intelligence officials knew all along of Osama bin Laden's hideout in Abbottabad, Pakistan. Jeremy Hammond, who admitted to being part of the internet activist group Anonymous, which claimed responsibility for the Stratfor release, was arrested back in 2012 as part of an international FBI raid. His sentence of 10 years in prison was the maximum sentence permitted under his plea deal.